Hello students, today we discuss on a new topic cancellation of tender in module number 3 tendering. So cancellation of tendering shall apply in one of the following cases. First one is a of the objective or scope of investment state in the tender investigation uh, document. Second is there is a evidence so that the party calling for a tender with tenderers, and third one is all tender failed to satisfy the basic requirement of tender invitation document, and last one is there is evidence to show that all the tenderer could to adversely affect the interest interest of a party calling for a tender. And second point of the cancellation of tender is based on the decision of the authorized person. The party calling for a tender shall be responsible for notifying all the tender who participate in the tender of a cancellation of a tendering. Now another new topic start is financial liabilities when tender is cancelled. So first is in case of the cancellation of tender, no due to fault of tenderer, the party calling for a tender shall be responsible to compensate tender for their cost of participation in a tendering on the basis of a current state regime and cost level, except in a case where the tendering was called because no tender satisfied the requirement of a tenderer invitation documents. Second is if the tender was cancelled because of an alteration of the objective or scope of investment, the authorized person shall make a decision on a compensation for a cost which shall be paid for the project budget. And if the tender was cancelled for any another reason due to the fault of the party calling for a tender, so individual member of such a party calling for a tender shall be liable to pay compensation for the cost. And third is if tender was cancelled due to collusion by a party calling for a tender, one or more tenderer, the individual responsible for such a collision shall be liable compensate of other tender for their cost. Now new topic is rejection of tender. So in some of the cases tender is rejected. So first is a tender failed to satisfy the important requirements set out in the tender invitation documents. Second is a tender failed to satisfy the technical requirements based on the assessment criteria. Third is a tender contained arithmetical error with total absolute value more than the 10% of the tender price except for a tender package for a consultancy service, or except where the tender does not accept the arithmetical error identified by the party calling for a tenderers. And fourth point is a tender contain discrepancies with the total absolute value of more than 10% of the tender price except for a tender package for a consultancy service. Now new topic we start is a topic name is a termination of a contract. So termination describe a contract expiring or being brought on, to an early end. So the effect of termination is to bring the contract an end of certain point and absolve parties to majority of ongoing obligation. uh, Accrued right being those right to which the party had to come entitled during the terms of contract are not affected. So such a right continue to enforceable the following termination. So a party which party wishing to terminate the contract should always consider the legal basis upon which can be entitled to terminate the contract and consider the practical commercial implication of such a termination, and the interest of a party seeking to terminate may be better served in allowing the contract to continue, like where there is a ongoing entertainment to receive payment under the terms of the contract. So the terminating party should also be mindful of a potential risk of a claim against them the wonderful termination. So the terminating party must ensure that they comply with all the procedural requirement termination of both the common laws and contract. Now next point is how to terminate the contract. So contract is terminated when one party is it elect the exercise right to bring the contract to an end, and that right arise like a common law and or and by express terms of the contract. So generally termination of the contract is on totally basis on law and or contractual terms which require positive action from the terminating party, and it is extremely rare for automatic termination to be provided in the contract. So unless the contract expressly allows for automatic termination, a positive action such as serving notice of a termination will be required. Now next is a affirming the contract. So affirming the contract refers to situation where the non-defaulting party is aware of a breach and its right to terminate of a affirm, but opts not to terminate the contract. So affirmation can be expressed or implemented by the contract of the non-defaulting party. For example, if the non-defaulting party continue to perform the contract as if it is genuine, and it party affirm the contract, they lost their rights to terminate. So these are the important things. Now termination at a common law. Now, right to terminate may arise in a common law depending on the types of breach, and the a right to terminate may arise breach of a condition. Like a condition, contractual terms refer to term the contract that if the breach gives non-defaulting party the right to either treat the breach as a repudiation and terminate the contract or affirm the contract. So an alternative right to terminate can also arise in a common law on breach of intermediate terms, and intermediate terms refer to term for which remedy for its breach depend on the nature and effect of the breach, and if the breach is also serious so as to have an effect of depriving the non-defaulting party of substantially the whole benefit of the contract, the non-defaulting party will entitled to terminate the contract. So the remedy will be that the non-defaulting party can be treated as the breach as a repudiatory breach and terminate the contract as if it were breach of a condition. So in both the cases the non defaulting parties eliminated claim damages, and if the breach does not go to the roof of the contract distributed, the non-defaulting party substantially the whole benefit, then the breach of intermediate terms will be treated as it was a breach of warranty. So a breach of warranty does not give rise rise to right to treat the contract as a repudiated, and the non-defaulting party will not be entitled terminate but could claim damages. So a repudiatory breach does not automatically terminate the contract. So instead of non-defaulting party must expressly elect to accept the repudiation and terminate the contract or affirm the contract. So in both the instances, the non-defaulting party is entitled to claim the damages. Now, this topic is a termination pressure pursuant contractual terms. So, this topic we discuss in a next lecture. Thank you.